All right. Hello and welcome. Hello and welcome. Thank you all so much for being here. Welcome to another episode of the Empowered Immigrant Live. My name is Otis Landerholm, and I am your host here at the Empowered Immigrant Live. I'm also the founding attorney at Landerholm Immigration A.P.C, where we fight for your American dream. And thank you all so much for being here. So remember that the Empowered Immigrant Live is here to train, teach, inspire, and empower immigrants to make the most out of immigration law and to make the most out of their lives. Today, our theme is Mandamus cases, all right? And really, we're talking about pushing the government if your immigration case has been delayed unreasonably, all right? If your case is way outside of normal processing times, then let's talk about this. So my question always is, hey, do you want to get a green card this year? Do you want to come out of the shadows this year? Do you want to at least see what your options are this year? Because if so, go for it. And I'd love to help you with that. My firm is on a mission to win 10,000 immigration cases in the next 10 years. And we'd love for your case to be one of them. Okay? As I'm talking about our theme today, if you have questions, please submit your questions. I'll do my best to answer them here live. And so thank you. Thank you for being here. So again, we're talking about mandamus actions, which are federal lawsuits. And so, as always, I'll start with the basics, right? And the basics are, I don't know, did you know that immigration actually has a duty to adjudicate their cases? All right, a person pays a filing fee, a person, files their case to USCIS or to the immigration court or in whichever process you're in. You're doing that. The government now has a duty to adjudicate your case, okay? And that's granted by the Administrative Procedures Act, and that's granted by various issues inside of federal law. And so did you know that if they fail to do that, you can file a lawsuit against them? You can sue the government, all right? And specifically, it's like you can sue the government, you can file a lawsuit when they fail to reasonably adjudicate your case. Okay? And so today, that's what we're talking about. And we're talking about, okay, what can you do if your immigration case is unreasonably delayed? All right? And we should put bold and underline that word, unreasonably delayed. Okay? So imagine that you filed a green card application or an asylum case or a citizenship application. And imagine you filed it years ago. All right, maybe back in 2017, for example. And imagine it is still 7 years later, because we're filming this now in 2024. Imagine your case is still delayed. Imagine you haven't even been called in for an interview yet, and nothing has happened in your case at all. That's right. So then, lawyer, what can I do to push this forward? This wait, this delay is ridiculous. All right, what can I do to push this thing forward? Well, what I like to say is 3 steps. Okay? If you're taking notes, there's 3 steps that I like to do in cases like this. Okay? What I like to do, step number 1, you ready for them? I like to request and review all the records. Because I want to make sure your case was strongly presented from the beginning. I want to make sure if we're going to push the government to issue a decision, I want to make sure I have a really good idea and am confident about what decision they would make. All right? I want you to have a strong case, in other words. I want to make sure that when the government schedules your case for an interview, that you aren't going to cause any other or extra delay on our end trying to correct problems in your forms or trying to submit additional documentation to support your case. It's like, let's make sure that your case was ready and well done to begin with. Okay? The other thing, I'll just say it, right? The other thing is sometimes when we review the case, let's just really make sure that it's a case we want to push. It's like sometimes you don't want to push a case. if you're going to lose it. All right? And so that's another nuance, right? Sometimes there's legal advice that you want done. You want a lawyer that knows what they're doing to review all your records first. And if there's doubts or whatever, hey, let's tighten that up. Let's make the case stronger. Let's file an amended form. Let's get the corrections that are necessary on file first before then going through the next steps of the process and pushing your case even more. Okay? So that's all step one. Review those records carefully. Make sure you're getting good advice. Make sure you know what you're getting yourself into. Okay? Once you're done with that, which that takes several months, all right? The FOIA process takes several months, and you want to get those back and then review them carefully and then create any amendments and then send those off. Like, that can take some months, okay? After you're done with that, though, now you can start to push the government. And so if it's an asylum case, what does that look like? Often the recommended course on an asylum case is you file what's called an expedited request. All right, and I did a whole training recently on how to do that. You know, go to our YouTube channel, type in expedite request, land or home immigration. You'll see my video, you know, about how to create an expedite request in your asylum case. So for asylum, it's an expedite request. If it's not asylum, if it's a citizenship case, if it's a normal USCIS, like an application for a green card, adjustment of status, something like that, then you do inquiries to the government, and I like to do what we call an ombudsman request. Okay? Whether it's an expedite request or an ombudsman request or a congressional inquiry, sometimes that accomplishes the same thing as an ombudsman request. So regardless of which of those things you're doing, when you're doing them, you want to explain two things, and you want to put it into the record. All right? Number one, you want to show and explain that the delay in your case is unreasonable. Say that. This has been delayed since X date. I've done these inquiries. There's still not even the next step on my case. This delay is unreasonable. All right? And the second thing you want to show is that that delay is causing you harm. You want to show that that delay is causing you and your family hardship. And you want to put those things into the record. Make sense? Okay? So that's step two. All right? Step one is the FOIA process, reviewing, requesting all the records. Step two is you push USCIS with an expedite request in the asylum context or with inquiries and ombudsman requests if it's with USCIS. And when you're doing that, you want to show that, one, the delay is unreasonable, and two, that delay is causing you harm, and you want to explain that. All right? I haven't been able to go visit my mother for years because USCIS has failed to at least give me the next step in my process. And my mother's aging, and I want to see her before she dies, and this delay is causing me hardship. Like, put that in the case. All right? You want it to be in the record so that you set the stage for step three. Got it? Okay. So we've gone through the first two steps. So then what is step three? Step three is what we're talking about, right? And that is a lawsuit. Okay? You can prepare a mandamus action. You can prepare an action under the A.P.A. All right? Typically when we sue under the A.P.A., the Administrative Procedures Act, we're also suing under the mandamus statute. And so what is that? What is that? What it is it is a federal court lawsuit. It is not an immigration court. All right? It is not an immigration court. It is a federal court lawsuit, all right, where you're suing the government alleging that they are unreasonably failing to do their job. They're failing to adjudicate your case. Their delay is just unreasonable, all right, and it's causing you harm. Okay? Now, the steps involved with that depend on a lot of different things, all right? And one of the things they depend on is which federal district you are in. So if you're in front of a computer right now, go to Google, keep me up, But if you're in front of a computer right now, keep me up, but go to a Google search and type in, what federal district am I in, and then put your zip code. And it'll tell you, like right now, right here, right now, I'm in Oakland, California. We are part of the Northern District of California. So if we file this type of case in federal court, we've got to file the rules that are set in place by the Northern District of California Federal Court. Okay? And there are lots of different federal districts. There's 3 in just the state of California. All right? But throughout the United States, there's lots of different federal districts, and so you want to be aware about which district you would be filing in and the rules in that district. And your lawyer, will need to be licensed in that district, or there's a process they can go through to become licensed or to appear, we call it pro hoc vice, which is like just on one case at a time, they can appear in other districts, okay? And so, but if it's like a San Francisco Asylum Office case, if it's a San Jose adjustment of status case, anything in the Bay Area, we're talking the Northern District of California. So anyway, so check out which district you're in. Then how you move forward, you might draft first the Mandamus or the APA complaint, have your lawyer draft it. You might have your lawyer first send that complaint to the U.S. Attorney's Office. And then sometimes just doing that, the U.S. Attorney can see it, they can see that it's an unreasonable delay, and they can say, hold on, you don't need to file this case to the court yet. Give us 30 days, we'll get something scheduled for you. Sometimes that can happen, all right, depending on where you're at, depending on, lots of different factors involved. It sometimes is worth at least trying, okay? And sometimes that doesn't work, and you just got to file that complaint to the federal court. There is a filing fee for doing that, all right? And then once you file that lawsuit, now you've got federal litigation happening. And so the government might answer the complaint, they might oppose, they might file a motion to dismiss our complaint. And when that happens, now, okay, we need to file an opposition to that motion to dismiss. All right? And ultimately, the judge will make a decision as to whether or not to dismiss the complaint, or the judge could say, no, you've got a case here. We're going to move this case forward and allow for discovery, allow for more litigation to happen. Typically, if we're at that stage, most of the time, USCIS will say, okay, let's schedule this interview. All right? No, typically, they don't want to go to a trial. They don't want a bunch of discovery. They don't want to go through that hassle. Typically, it's much easier for the government to just schedule the interview and push your case forward, and that's what you want anyway. Okay? And so that's the way it works. In the 1% of the 1% of cases, you might really go through the litigation process. And so you want to be prepared for that as well, and you want to talk that through at the outset, because there's never a guarantee, right, that the federal judge will agree that it was a quote-unquote unreasonable delay, right? All immigration cases have some delay. And so there's always a question of how soon is it wise to file this type of case? How much delay does there need to be before this type of case is winnable? Well, that's a difficult question because it's an unreasonable analysis, which is a subjective analysis by the specific court, by the specific judge, and based on the specific facts of your case. Okay? Which is why it's worth talking it through with a lawyer, why it's worth really reviewing the records carefully first, etc. Got it? So there you go. There you go. So let's get into your questions. If you have questions, then let's get into those. And thank you all so much for being here. I really appreciate your being here. And so, Yanette, I see your question here. You say hello. I helped my son arrive to the U.S. and I have to waive it with a waiver, el perdón, with your U visa. So, Yanette, hello. Thank you so much for asking that question. Thank you for being here. Your question was asked in Spanish, so thank you for that. We will do this episode again in just a few minutes in Spanish, okay? But for right now, okay, if you helped your son enter the U.S., yes, that triggers inadmissibility. But the U visa does have the power to waive it. And so when you're filing for your U visa, you submit the waiver on Form I-192, and you have to include every reason that the government even might say that you're inadmissible, to waive all that stuff, including that, bringing in your son. And yes, you should be okay to do that. And we've done this, we've won this. This is not the worst inadmissibility ground by any means. And so, so there you go. Okay. So yes, I hope that was helpful. If you need help with how to do that type of waiver, how to do the U visa properly, we'd love to help you. Feel free to reach out. Nice. So let's see. I got some friends here on Instagram. Tiffany Moya, hello, and Katarina Welch, hello. Great to see you. And Arej6, hello. Great to see you. And Kevin G, great to see you. And Jose, thank you for helping me with my asylum process. Appreciate it. Hey, I appreciate you. Jose, thank you so much for being here. And Tiffany, you say your husband has been deported 10 years ago. Can he request a forgiveness? All right. Wow, Tiffany, thank you so much for asking that question. Sometimes the way to waive a deportation, first we need to request all those records. If it's just a deportation order, which I know that's a hard thing to... Let me say it like this. If it's a deportation order and that is the only inadmissibility ground, that triggers a 10-year bar. That bar is waivable on Form I-212, okay? We call it an I-212 waiver. The key about deportees is he cannot have tried to re-enter unlawfully after that bar. All right, if he did that, then he triggers a permanent bar and there's no waiver available. That's not totally true. There's some things that can always be done, all right? And so, Tiffany, if you want to talk it through, and I say the permanent bar is unwaivable, the permanent bar, you have to be outside the United States for a period of 10 years and demonstrate the physical presence before even trying to request the waiver, okay? So it's not like 10 years go by and now you're no longer inadmissible. No, you're still inadmissible, but you're eligible to apply for a waiver after the 10 years have gone by. So Tiffany, your husband might be eligible for that. The best thing to do is let's start with a consultation and let's request all the records so that we know clearly where we're at, what we can do, what's really the situation for him. And if we could bring him back into the United States, hey, man, I love cases like that. Okay? That's what lawyers are here for. That's awesome. So, Gagastikal, I see you. Hello. Welcome to Instagram here. Everybody, whether you're here on Facebook, LinkedIn, Instagram, TikTok, YouTube, thank you all so much for being here. Okay? So I think those are all the questions that I've got. So that's perfect. So thank you all so much. Before I wrap up, I'll give my little empowerment tip like I like to do. My tip today is this, all right? Don't be afraid to say whatever needs to be said. Okay? Don't be afraid to say whatever needs to be said. Don't live in fear. If you've got something on your mind that needs to be said, even to your spouse or to your kids or to your parents or even to your boss or whatever, right? It might have some consequences. It might cause friction, right? But you know what? It is so much better to say what needs to be said and to open that conversation. It's like that is how progress happens. Okay? And sometimes that's a conversation about your immigration case. All right? Husband, mother, whatever it is. I am tired of being in my current immigration status. I want to do something about it. Can we go talk to a lawyer about this? All right? Brother, sister, you're a U.S. citizen, I'm not. Would you mind sponsoring a visa petition for me? Right? Whatever it is. Like if you got something that needs to be said, don't be afraid to say it. All right? And if I can help you in any way with any of that, hey, please just contact us. We're here to help. We'd love to help. Okay? So I wanted to share that today. That's my empowerment tip. Hope it's useful. Hope it's helpful. Hey, if this video has been helpful, my best advice is go to our channel in YouTube. And when you do, click the subscribe button. All right? Some people see our videos often and think they're subscribed. Well, you might not be subscribed, right? So actually go to the channel and hit that subscribe button. And then I also recommend hitting the notifications bell, because when you do that, now YouTube will notify you whenever we upload a new video with new updates and news and things like that, so that you can stay informed. Okay? Gagastikal, I see your question here. You'll be my last question for today. All right? And then I'll do this in Spanish. So your question is, what's the implementation of filing for an EAD replacement after divorce for VAWA? What's the implementation of filing for an EAD replacement after divorce for VAWA? So thank you for asking that question. All right. So whenever you're looking at your work permit, your EAD, and whenever it's going to expire, say in the next 6 months, file the renewal request. All right. Even if your VAWA case is still pending, even if you might get a green card during the next 6 months. All right. It's still wise to go through the process, file the extension request for your EAD so that you maximize your chances of getting that EAD approved, all right, and then you don't lapse work authorization. Okay, that's the best advice. You can do that even if you've gotten divorced. Divorce is irrelevant for that. The only thing that divorce affects when it comes with VAWA is you must file your VAWA case within 2 years of your divorce if you haven't filed it already. Sounds like you've already got it on file. Okay? And so that's it. That's it. All right? But Gagastikal, thank you so much for asking that question. Thank you so much for being here. I really appreciate you. Okay? All right, ladies and gentlemen, thank you all so much for being here. That's all the time that we've got for today. I will do this episode in Spanish in just a few minutes, so if you speak Spanish, join us there. As always, if you have an immigration case, hey, please give us a call. We are here to help. We'd love to help. My name is Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C, where we fight for your American dream. And we'll see you next time on our next episode of the Empowered Immigrant Live. Thanks a lot, ladies and gentlemen. Have a great day. Take care. Bye-bye.